and welcome to Preventing Harassment and Bullying in the Workplace. This is Session A.
Session B is for managers and supervisors, and that will follow.
This class is part of your organization's mandatory harassment prevention training class. Thank you for your participation. Plan on spending the next hour watching this video and taking the test. I'm Marcia.
And I'm Philip.
And we're ready to get started with the training.
This course is brought to you by capreventharassment.com, and it is dedicated to a professional and respectful workplace. There are 5 objectives to this course. The first, build skills to resolve employee issues.
Employees invariably have issues that come up, and we want to make sure that you know about your resources and tools available to you.
Objective number 2, increase employee morale and productivity.
Employee morale affects everything that we do, not just productivity, but also commitment, quality, customer service. Those are all very important aspects of your employment at this organization. We want to make sure that your workplace is inclusive and respectful.
Objective number 3, learn about your policies.
We want you to know about our policies and ensure that we are consistent in the application of those policies, because the minute we're inconsistent, someone could say that we are unlawful or discriminatory, and we certainly don't want that to occur. Having a policy manual ensures that we are consistent across the board.
Objective number 4, increase professionalism as an organization.
If we're professional and respectful, we shouldn't have any issues. So that will be our goal.
Objective number 5, comply with the law.
There are many laws you should know about, both on the federal level and the state level, that give you rights and responsibilities, and we'll go into that in great detail. While this mandatory training is required by law, there's certainly a lot of other good reasons to make sure everyone is on the same page.
With those 5 objectives, the end result will be to help create a healthy and respectful workplace.
Let's go over what to expect in the training class. First of all, the process for this course includes a video with some case examples, an activity, and a certification test. At 2 separate times, we'll provide you with codes. These codes will be evidence that you're actually watching the whole video. You'll have to insert those codes into the certification test. The test includes multiple choice questions, and you'll need to pass at a rate of 80%. We'll provide you with ongoing support if you have any questions throughout the process. All of those activities should take about an hour. There's been a heightened awareness of sexual harassment in the workplace.
And as we all well know, harassment is in the news.
Politicians, entertainers, sports figures, the list goes on and on. Certainly harassment can impact people's reputation and even their career, so we need to take it seriously. Most of the situations involving Me Too were sexual assault. We're going to talk about sexual harassment in the workplace specifically. Harassment is not new to employees. Employers are required to have posters in a central location, like a break room or a supply closet. Those posters detail information about your rights and responsibilities in the workplace. We also have an employee handbook and a policy manual, and we've perhaps done trainings in the past, but by following our policies, we demonstrate that the employer takes this topic seriously. This training is all part of your employer's harassment prevention program. The topics for training will be about discrimination in general, as well as harassment, not limited to sexual harassment. We'll also talk about the topic of retaliation and abusive conduct or bullying in the workplace. So let's get into the training. The first topic is going to be legal issues, which will talk about the rights and responsibilities that you have. Secondly, we'll talk about behavioral issues, how you should communicate and interact with your coworkers. And thirdly, we'll talk about some practical issues, what you should do or say if you've observed or have been victimized by harassment in the workplace. Our goal with this training is to educate you about the rights and responsibilities you have in the workplace, but also to give you some ground rules for professional and respectful interactions with your coworkers. and to also give you some resources in case there is an issue that ever comes up. In this section, we'll talk about legal issues and the many laws that provide you with rights and responsibilities. We'll discuss the legal issues having to do with discrimination, harassment, retaliation, and abusive conduct, or otherwise known as bullying in the workplace.
There are both federal and state laws. Federal, there are U.S. Supreme Court cases and U.S. EEOC Guidance. State laws, we have the California Fair Employment and Housing Act and various assembly bills and Senate bills that provide oversight.
Let's talk about the recommendations from the U.S. Supreme Court and the EEOC to do this training. Several states have their own mandatory training requirement as well, such as New York, Connecticut, California, Hawaii, Maine, Massachusetts, and several other states. Let's talk about the recommendations from the U.S. Supreme Court and the EEOC to do this training. In 1998, the U.S. Supreme Court had two landmark decisions that strongly encourage employers to conduct harassment prevention training. Those cases were Burlington Industries versus Ellerth and Farragher versus the City of Boca Raton. And in both of those cases, the employer was able to demonstrate what's called the affirmative defense because they took reasonable care to prevent and respond to the harassment that occurred. In both of those cases, the employees unreasonably failed to take advantage of any preventative or corrective opportunities available to them. Those cases demonstrate that employers should take proactive steps to avoid liability. In 1998, the EEOC provided a three-pronged approach as guidance for employers for preventing harassment. First, employers should adopt specific policies about sexual harassment, including a definition of harassment with real-life examples. Language about non-retaliation for those who come forward with complaints should also be included, as well as a statement that sexual harassment will lead to disciplinary action up to and including termination. Secondly, the EEOC said that complaints of sexual harassment must be promptly, vigorously, and honestly investigated, and valid complaints must be remedied. Employees must be offered multiple avenues of complaint, meaning a supervisor, a manager, or a HR professional that they could go to with any issues that they might have. Thirdly, the EEOC suggests that employers should consider training all employees, from the CEO to frontline employees, to ensure that they are sensitive to the issues of sexual harassment. Although the EEOC has strongly encouraged employers to do the training, many states take it further and have the mandatory training requirement. The EEOC is the agency that governs all the anti-discrimination laws, and here's a list of the federal protections that are afforded to employees. Basically, you cannot be discriminated against or harassed on the basis of race, sex, color, religion, national origin, ethnicity, or ancestry. Additional laws provide additional protections, such as over the age of 40, pregnancy and related medical conditions, military status, disability, immigration status, and genetic information. We'll go through each of these laws in successive slides. The major law dealing with discrimination and harassment on the federal level is Title VII of the Civil Rights Act of 1964. This law prohibits discrimination and harassment based on characteristics such as race, sex, color, religion, national origin, ethnicity, and ancestry. Title VII prohibits discrimination in hiring and promotional opportunities within the organization. It also proactively requires religious accommodation, which might mean days off or time off to pray, those sorts of things. This was really the first anti-discrimination law, and that's why it's so broad. Another law pertaining to discrimination and harassment is the Age Discrimination in Employment Act. It protects employees over the age of 40. It was the ages 40 to 70, but then the upper limit was removed. So like Title VII, it applies in hiring and promotional opportunities within the organization. So in terms of hiring, no questions can be asked about high school graduation dates or age, but it's okay to ask about college graduation dates. But also like Title VII, it applies to harassment as well. So no jokes or comments or teasing about age. Another law is the Pregnancy Discrimination Act, which protects people who are pregnant or have related medical conditions, such as miscarriages, infertility, or an inability to become pregnant. The only exception to that would be whether the qualification was a bona fide occupational qualification, which is a very limited exception. Another protected category is military status. Under the Uniformed Services Employment and Reemployment Rights Act, an employer cannot discriminate based on military status. Employers must hold the job open while the employee is out on active duty and reinstate them to the same or a similar position upon their return from leave. Another law which protects Americans is the Americans with Disabilities Act. Employees that are covered have a physical or mental impairment that affects a major life function such as seeing, walking, hearing, breathing. Employers are required to provide reasonable accommodation, but this accommodation can only be determined through an interactive process, which is handled by an individual such as HR or in your benefits department. This law also restricts medical inquiries to designated personnel, so make sure if you have access to any information that you keep it confidential and be respectful of employees' rights to confidentiality regarding their medical condition. And the Immigration Reform and Control Act has an anti-discrimination provision. It's not an EEO law per se, but it does have a provision which prohibits discrimination based on citizenship status. So yes, we need to verify an employee's eligibility and authorization to work with an I-9 form upon hire, but while they're an employee, we cannot treat them differently because of their citizenship status. And in 2008, the Genetic Information Non-Discrimination Act was passed, making it unlawful to discriminate against an employee on the basis of genetic information. So those are the federal protections afforded to employees. On the state level, it should be noted that many states have passed their own Fair Employment Practices law. Many of these laws mirror the federal protections, however, oftentimes they're given more time to file a complaint, or there's an expanded definition of who's protected under those laws. As an example, many states have protections for marital status, or veteran status, or political affiliations, or if you're a victim of domestic violence, assault, or stalking. So check your posters so you know what the protected categories are in your state. To summarize the information in this section, recognize that there are many laws, both federal and state, that provide you with rights in the workplace, but you also have responsibilities. Your responsibilities are obviously to do your job, but also to behave in a way that is conducive to the standards of conduct that are outlined in your employee handbook. Be sure that you're not infringing on the rights of others in the workplace. As we mentioned in the beginning of the training, you'll need a code to indicate that you're watching the entire video. The code for the middle of the session is CUFXV, and that will be on the test. So write it down.
Section 2. Behavioral issues. Follow the standards of conduct and be respectful and professional.
From a behavioral standpoint, there's several issues that can get employees into trouble. This usually happens between interactions and communications with your coworkers. The first issue is profanity. Obviously, profanity entails anger and emotion, and there's no place for it in the workplace. Also, jokes. Jokes are fun. However, sometimes people are the butt of jokes, or jokes are made at people's expense, and so those are jokes that are going to cause you issues. Yelling or raising your voice indicates a lack of control over your emotions. So when there's the intensity and frequency of raising your voice, that could be problematic. Also, name calling. You should not engage in names that are going to be offensive to other people. And this would include calling people names like honey, dear, sweetie, babe, those sorts of things. Be careful about your electronic communications via email, Facebook, Instagram, Snapchat, social media, and even online games. Recognize that behavior that may be socially acceptable, such as flirting and joking, is probably not appropriate in a professional setting, so be aware of your behavior and act accordingly. Sometimes some of our communications and behavior has a bit of bias in it. There's prejudice or preconceptions or assumptions that we make about people. And there's also the element of unconscious bias, microaggressions that are comments that are made that don't intend to offend or humiliate or embarrass people, but that's the end result. So we need to be cautious of those sorts of comments and behaviors.
So let's start with the impact of harassment. And first with the impact on individuals. Physical and emotional stress and health issues are one element of harassment. Second, impact to self-confidence and pride in work. And a third, but not final, is the job career reputation. Another impact is on the team. There's poor team cohesion, lower productivity, loss of morale, stress, and interpersonal conflict. The third is impact on the organization. Cost of investigations and settlements, liability, high turnover and loss of valuable employees, negative publicity, and loss of contracts, grants, public trust, and confidence.
For all those reasons, we want to ensure that people's behavior is appropriate, respectful, and professional. We're now going to talk specifically about sexual harassment, but first, just a couple of general comments. Remember that harassment can be based on other elements, not just sex. It could be based on race, color, religion, or any of the other protected categories that we talked about. It is subject to interpretation because we are different people with different backgrounds, different genders, different ages. We all have different senses of humor and different tolerance levels. So what offends or humiliates one person might not offend another person. However, it is subject to the standard of the reasonable person. Would a reasonable person be offended given the circumstances? And certainly if anyone tells you that they're offended, you need to stop that behavior at once. There are 4 types of sexual harassment. The first is sexual favors, or quid pro quo. That would be if a manager or supervisor abused their power by saying something like, if you do this for me, I'll do this for you. Or if you don't do this for me, I won't do this for you. The other forms are physical, verbal, or visual. And your policy will include some real-life examples. Here are some scenarios that are commonplace examples of harassment in the workplace, so we can make sure we understand the definitions.
So scenario number 1, joking at work. 2 employees are observed talking in the break room. Both are laughing and are engaged in the conversation.
This is probably fine as long as the employees are not joking about another person or making comments or jokes at the person's expense that demean or embarrass or offend another employee. So joking at work is fine as long as it's not about a person or about a protected category.
Scenario number 2, complaints. An employee has complained about unfair treatment, so the supervisor is unsure how to treat them and ends up avoiding the employee.
An employee has the right to complain and shouldn't be treated any differently as a result of that complaint. So if an employee makes a complaint and they're being ignored or avoided or ostracized, that's changing the terms or conditions of their employment, and that could be considered as retaliatory.
Scenario number 3, electronic communications. You're friends on Facebook with several other employees and you notice inappropriate postings about a coworker.
Your electronic communications could be subject to your employer's electronic communications or social media policy. In most cases, disclosing confidential information or communications that are disparaging or disloyal to the employer are restricted. Yes, there is the element of free speech. However, in many cases, employees' behavior online has been subjected to disciplinary action or termination.
Scenario number 4, hugging. An employee just got back from a long vacation, is happy to see his or her coworkers.
Take a look at these 3 photos and you'll see 3 very different responses to the hugging. Your policy outlines behavior that could be physical harassment, and usually that is pinching, patting, kissing, hugging, or putting your arm around someone. With regard to hugging, it can create a hostile workplace when it is unwelcome and pervasive. The rule of thumb is that you can probably hug your close friends, but not all the time, and you can probably hug someone if you ask and they say it's okay. But you shouldn't hug someone who you supervise, and you shouldn't hug a coworker with whom you're romantically involved.
Scenario number 5, body language. An employer stares, gives mean looks, or wags fingers and becomes visually angry with coworkers.
Here's an example of visual harassment. Could be gestures, facial expressions, pointing your finger, and those types of displays, which are aggressive, and they could create a hostile work environment. Even if nothing was stated, the type of behavior that we see in these photos could be problematic. Facial expressions, raising your voice, yelling at someone could be examples of aggressive behavior, abusive conduct, or bullying in the workplace as well, and we certainly don't want that to happen.
Scenario number 6, friendships. Your coworkers are friends and ends up spending weekends and evenings socializing. Several romantic relationships have resulted on the team.
The answer is that although we cannot control your off-duty conduct, employees should refrain from public displays of affection and realize that their conduct could be questioned should the behavior come into the workplace. Of course, friendships in the workplace are fine, but keep all of your interactions professional.
Scenario number 7, dating. An employee asked another employee out and she said no. He repeatedly asked her out for a date.
The answer is, it makes sense that you may want to date someone that you meet on the job. However, if you ask an employee out for a date and they say no, do not repeatedly ask them out. That could be an example of harassment. Also, employees that do not report to each other can date, but not if there's a reporting relationship. That could cause issues with conflict and preferential treatment in the workplace. Also, employees in relationships should in general be cautious because the romance might end, and what will result is conflict and bad feelings.
Scenario number 8, compliments. A coworker tends to give you compliments on a regular basis, saying things like, "Hey, you look great," or "Have you been working out?"
Compliments are nice, of course. However, you want to be careful. The answer is, it's often not what you say, but how you say it. And compliments may be misinterpreted due to the tone, content, frequency, or intensity of the attention, among other factors. If the person has said they're uncomfortable being complimented, certainly do not continue this sort of attention. And remember that all workplace communication should be professional and respectful at all times. Most of those examples were commonplace. We just wanted to give you a sense of the ground rules for engaging in communications and other interactions with your coworkers. The key is to ensure that we're always being respectful and professional. That summarizes the second section, which was behavioral issues.
Section 3, practical issues, resources, and next steps. When it comes to reporting harassment, speak up if you know or suspect a situation. Second, multiple avenues of complaint exist. through human resources, your manager, supervisor, manager, or executive, or anyone really in a management position.
Remember, it's the employer's responsibility to investigate any claim of harassment promptly, vigorously, and honestly. But we need to know about it, so it's your responsibility to speak up if you know or suspect a situation that's going on. It's your choice who you want to go to with any complaint, concern, or question. You could even submit the complaint anonymously. However, it's very difficult to investigate a claim if we don't know specifics. Oftentimes, employees are hesitant to come forward with information regarding a complaint or situation, but you should know that your organization's policy includes a non-retaliation provision, meaning you can't be retaliated against for coming forward with that information. Employees do have the right to complain, and we want to be respectful of that, but certainly you should not fear retaliation for complaining or even being involved as a witness in an investigation. If that occurred, that would be an example of retaliation. A synonym for retaliation is revenge or payback, and it typically involves three different elements. First of all, a protected activity, such as making a complaint. Secondly, adverse employment action, some result of the complaint. And then thirdly, a connection between the protected activity and the adverse action. Your organization has an investigation process in place, which requires employees to come forward as soon as possible with any question, issue, or problem. One thing to mention is that we cannot ensure 100% confidentiality. However, we will only share information with people who have a demonstrated need to know. And employees should try to maintain the confidentiality of their information as well. In terms of resources, a good place to start is the Employee Handbook or the Policy Manual. Inside that, you'll see policies on EEO as well as harassment and your complaint handling procedure. You can also read about other policies that we've mentioned, such as electronic communications, social media, dress code, and other standards of conduct that are important to you in your employment. Another great resource of information are the employment posters that are hanging in a common room in your employment or maybe on your intranet. There's both state and federal posters that have information such as the agency to contact and other important information about your rights in the workplace. So as your final activity, we'd like to ask you to do two things. First of all, review the employment posters. EEO is a law as well as your state Fair Employment Practices poster. Also, review the Employee Handbook or your Policy Manual to see what's included in your EEO policy, your complaint handling procedure, as well as the other policies that we mentioned. So in summary, we want to make sure that you're aware of your conduct and how it impacts other people.
Understand the legal issues, rights, and responsibilities.
Make sure that you separate your professional behavior from your social behavior.
And last but not least, seek advice from HR or your manager if you have a question, comment, or concern.
Now you're ready to take the certification test. The certification test consists of 10 multiple choice questions. They're not that difficult. They are just meant to ensure that you have comprehended the material in this short video. As we mentioned, you will need the code from the middle of the session as well as from the end of the session. And that code is CGFUX. You have to answer at least 80% of the questions correctly. If you do so, a certificate will be generated and an email will be sent to you with a copy of the certificate. And a copy of the certificate will also be maintained by your employer. Thank you for participating and congratulations. We hope that you've enjoyed this short presentation and that you will take this topic seriously. If you ever want to reach us, you can access us through the website uspreventharassment.com. Thank you very much.